Okay, every day, Nathan. My name's always up. Okay, so good morning, and a few of these classes will be either in this room or a different, whatever. So just, it's all in your syllabus kind of thing, so you know where to go every day. Okay, so today we are going to do a couple of things. One is we're going to finish a couple of slides from last day. I'm fairly confident we'll finish, be all caught up, no problem, by the end of today's class. One of the, and I'll have to post this later on the board. Ooh, I like this room because I can see. I'll have to post this later, but we have a logistical issue, and I don't know how to resolve it yet. So November 12th will be your presentations day, right? So you have an assignment that consists of a written portion and a presentation portion. And the 12th is the day for presentations, but there are too many people in this class to do it all in that day. So I have to do two things. I have to figure out, how we're going to do this. And one of the options, and I don't know because the school has to give me a room and it has to give me time, so I don't know what they're going to say. But one possibility is to break you up into two groups. So I'm going to post that information on Moodle as soon as I know it. But if there's anyone that has a hard conflict or a problem or something where you either have to go on the 12th or you can't go on the 12th, or if we get another day or whatever, then you'll have to let me know because of other classes or what have you. So we'll figure that out. But the main thing is just timing. There's just no way to do everybody every 2 hours for presentations. Okay. Our usual 10-30-60 rule, the golden rule. Okay, and any question? I know. Just, I don't know, just find a seat. There's lots of chairs. The problem is getting the space. There's one there, two there, one there. And squeeze. Squeeze. Okay. Okay, so let's pick up where we left off last day. Can anyone confirm for me? This is what I made a note of with this slide. Does that sound right? Anyone remember? Is that the last one we did? And we did it, right? Yeah. Did we do it? Okay, great. So then we can move on to the next slide, the next issue, which is competence or quality of service, right? So now we've gone from the theoretical, the philosophical underpinnings of how we have to conduct ourselves and our ethical rules and our ethical obligations. And now we're talking about a bit more of what the model code gives us in terms of guidance for competence. So if you are not competent, if you are the star of the real estate bar, and you know history, and you know the cases going back to the 1800s, you cannot do a family law matter if you are not competent, right? And we talked about how do we overcome that problem. Your client comes to you and says, look, I really want you, and by the way, most clients will choose lawyers of a similar age and gender and so on, so they can identify with them. That's just sort of anecdotal. But they really want you for some reason. So what our rules tell us is, if you are not competent, you must decline. I'm sorry, I cannot help you. And you can watch the retainer and the money go out the door. Too bad for you because you're not competent in that area. But you have to proactively identify that, right? You have to maintain your competence in the areas where you do practice. And remember our standard in terms of negligence. Our standard is a reasonable lawyer in similar circumstance. So they won't compare you to a 20-year lawyer if you're a 2-year lawyer and so on. And did we read Model Code 5? Okay, let's pull it up. Model Code 3.1-2 comment. Did we read this already or not? 3.1-2. Remember, Rule 3 is our big fat rule. It's a rule with all kinds of good stuff in it, including competence. 3.2-1. Who's going to be our volunteer reader today on a bright and sunny Tuesday morning? Did someone tell me, did you do it or not already? 5 and 6. No, we did it. Okay. Quick, who do we have? Keener, Tuesday morning, 3.2-1. 3.2-1. All right.
Here?
1. Okay. 3 points. So read the rule and then go to commentary 5.
Okay. A lawyer has a duty to provide courteous, thorough, and prompt service to clients. The quality of service required of a lawyer is service that is competent, timely, conscientious, diligent, efficient, and civil.
Okay, so we have that notion of competency. There's also the notion of quality of service, because if you're not competent, what kind of quality can you offer a client, right? And then without going through it, you'll see in commentaries 5 and 6. So we know that not only are you responsible for the model code rules, but all the commentaries. This is where they put the meat on the bones, and by they I mean the drafters of from the Federation of Law Societies of Canada. So what you have is in commentary 5 is examples, key examples of the kinds of competency that's expected and quality of service. Okay, so read those, know those you can take with you into the exam, right? Okay, so one of the, I don't know what this is. Misappropriation of funds, and the misappropriation of funds flows next in terms of, so we're in the realm of discipline, right? So misappropriation of funds is one of the, do you want to squeeze in there, or you're okay? You want to squeeze in over there? I don't know what to tell you. You can use this, but then your back will be. Oh, you can share it here. We're in the realm of discipline, right? And what's expected of lawyers. I mean, it moves, but it's just, it's not real. And so misappropriation of funds is one of the worst, right? Because what you do is when your client comes in and gives you a whole bunch of money, where do you put it? Where do you put it? Trust account. And it's called a trust account because you're entrusted as a trustee or your client's beneficiary. And so clients electing to recover misappropriated funds from the society, you must tell the clients they should advise the law society. So if the client comes to you and says, my last lawyer, you have to address that proactively, because misappropriation is, and it's criminal, right? So it's one of the most serious disciplinary matters. And we talked about this previously, this notion of the profession, right? Behind you stand all of your colleagues, so that discipline and sanctioning of a lawyer is done to protect the public. We have that public interest component to our work, and to protect the reputation of the profession. We're always concerned about the reputation of the profession. So that's the purpose of discipline by the Law Society, right? Every time. And we know some of the typical reasons for disciplinary proceedings, right? Theft, fraud, forgery, we've seen that, criminal activity, violation of a fiduciary duty, inability to practice law, right? When you're no longer competent or you haven't got capacity. Yeah, Jim.
Do they have a definition of serious addiction?
I do not think so. I do not think they do. It's going to be in the case law, right? Compared to precedents. What came before? Is it like? Is it similar? Is it more serious? And it's up to the discretion of the hearing. And then don't forget our good old favorite, failure to respond to inquiries from your governing body. Okay, so Swin is an example of a discipline case from 1980, and this involves sexual misconduct. And remember, we had that notion of conduct unbecoming and professional misconduct, right? We talked about that last day, that notion of what hat are you wearing? Are you wearing your lawyer hat, or are you wearing your baseball cap at your son or daughter's baseball game? You still have these obligations. So in this case, the issue was whether the conduct of the solicitor was conduct unbecoming a barrister and solicitor. Conduct unbecoming, right? Because at this point, he's transporting young girls across the border, you know, he's not like acting in his role. And the discipline panel says that if a member is found guilty of professional, this is bad because I have my back to you, professional misconduct or conduct unbecoming, then they may be disbarred otherwise. In terms of sanctions or available sanctions. So in terms of available sanctions for discipline, a finding of liability, page, let's see, go to page 123 of your text. Talk about discipline and sanctions, 123. 123. Okay, so I'm not going to ask you to read it, it's a really long paragraph, but you can read it, and what it'll tell you is that the sanctions, if misconduct is proven, include reprimand, fine, suspension, practice conditions, or disbarment.
Yes.
Or disbarment, the ultimate, right? The death penalty for misconduct. Okay, swing, right, swing. This is one of those FYI cases. This is one of those current issues in the media kind of a case. And it's a case of professional misconduct versus error in judgment. And it's from a 2018 case. So it's not in your text because, you know, didn't make it at printing time kind of thing. So it's really just FYI. You won't be tested on it. But here's an example where a lawyer was found to be in contempt of court by the Supreme Court of Canada during the course of submissions or arguments, you know, or something that he's doing in front of the Supreme Court. And what the hearing panel of the Law Society, so he's found in contempt of court, right? That's a statutory problem that he has. But then the Law Society says, we better look into this, right? Is this professional misconduct? Because what hat is he wearing at the Supreme Court, right? He's not the umpire, yeah. So, but the hearing panel says that his conduct was an error in judgment, not professional misconduct. Contrary to the rule that a court order and contempt of court will normally establish professional conduct, not in this case. Not in this case. And why not in this case? Because the lawyer is a partner in a law firm. He gets money from his client. He bills, and you're entitled to, no problem, deduct your bill, right? Generate your bill, take the money from trust, and you've got some money left over. He returns the money minus his fees to the client. The client disappears, and a creditor sues him. And what he does at the hearing panel level is he hires Alan Lesner, well-known, well-established senior member of the bar, you know, brings lots of gravitas to the thing, and he acts as an expert witness for Kerry. And here are the takeaways from this case. And what he does is he hires this, not as an expert witness, but as a senior member of the profession, who files an affidavit that says what he did, what Kerry did in these circumstances was fine at the time, right? The standard is comparing you to someone of your experience in your area of law, and also at the time, right? Because laws change and rules change. You have to work with the time that the conduct occurs. And what the hearing panel says is, it's important to find lawyers who are in a situation that where their ethical obligations are unclear to consult senior counsel, right? We talked about that. The evidence in the Lesner affidavit, so the more senior lawyer files an affidavit, and he says if he had been contacted, he would have been advised to do exactly as he did. So he didn't, but the evidence was compelling that at the time that Kerry, the lawyer in question, engaged in his conduct, that would have been what the senior lawyer told to him, and that there was no other guidance available to the profession in 2006. So you have to go back to the relevant time and look to see. So he, as far as the law side is concerned, was not found to be liable, and error in judgment does not rise to the level of professional misconduct unless there is serious or significant departure from professional standards, not a standard of perfection. Advertising. Again, this is another FYI. You can read it on your own in the interest of time. I am going to move on. This one is about an individual who used a referral service. What else is problematic for professional discipline and misconduct? Unauthorized practice of law. If you are suspended, good morning, yeah. Maybe, yeah. I don't know what to tell you. Maybe squeeze in there, but I don't have your chair back there, so. I mean, yeah, I know what you're about to do. If you are suspended by the Law Society for whatever reason, but you still engage in the practice of law. That's another charge, right? Unauthorized practice of law. Prohibited with certain exceptions, right? Right of an individual to act on their own behalf before a court or tribunal. Why? Why is that an exception? I know this is offered, but I need your name tags. Yeah. So why is that an exception to that rule, that you cannot practice law unless you are in good standing and registered with the Law Society? Why is there an exception for an individual?
Maybe the case is pending before the Law Society.
Okay, could be, yeah. Well, let's look at the next one. A person authorized by statute to appear as an agent, right? We know that's okay, right? Okay, now, yeah, we're going back to the first one. Why is a person allowed to act on their own behalf?
Access to justice.
Exactly, right? Self-represented. I can't afford you guys to go, I can do this, plus I'm smart. It's your worst nightmare. Worst nightmare. You don't want it. You have to tell them. We'll get to it. You have to tell them. It's very hard for you when it's a self-rep, but you have all these obligations. Anyway. But exactly right, right? You can't afford a lawyer, so you're not going to let me appear. It doesn't make sense. It's counterintuitive. Oh, Law Society and Wolf. Did we do this one? No. Okay, so Mr. Bold has he's got a whole relationship with the Law Society, right? He is convicted of unauthorized practice in 1998. In 2000, there's an injunction against him from acting as a lawyer. In 2006, he's found in contempt. And but he was advertising for legal services. And so he is found liable, and his discipline penal sanction is house arrest and prohibition of being a paralegal. Paralegals, right, in Ontario are governed by the Law Society in the same way as lawyers. Okay, monopoly on legal services. We talked about some of this, right? Why is there a monopoly on legal services? Justified, rigorous education, ongoing training, high hurdles to be registered, and benefits of someone offering services who is a license with the Law Society, or things like confidentiality, privilege, there's mandatory insurance, all those good reasons why we have a monopoly. But not everybody's happy with that monopoly. I know, right? I mean, you can sit here, except your back is here, the desk here. Okay. Yeah, so someone's always going to criticize the system. There's a couple of chairs there, but those are awful. And the criticisms include its unnecessary limitation on competition, people can't afford lawyers, and sometimes you can hire a paralegal. Law Society now supports that one. Okay. The model code also, in terms of competency and quality of service, recognizes sometimes you're going to have to delegate. No problem, we get it, it makes sense, right? And you're going to delegate to a junior lawyer or a student, maybe a paralegal, if you're lucky, a clerk or something. However, the model code indicates that you have complete, total responsibility for all business entrusted to you, and you must directly supervise those to whom you delegate. So you're not going to stand up in court and say, I thought the document was filed, I asked my junior or my paralegal to do it. Too bad for you. It's on you if you miss a limitation period or something goes off the rails because of your delegation. You're responsible. Too bad. We're done. Okay. We did this, right? Okay, so that is cleaning up last week's class. Yeah? Any questions? Today's class, maybe we're starting today's class. Today's good stuff. Who's that? Yeah? I know some of you said that was your favorite show. What kind of lawyer is she? In terms of our context of ethical practice, what kind of lawyer is she? Pardon? Pardon? I didn't hear.
Very ethical.
Very ethical. I need your name tag. No, I know. Very ethical. Okay. Who watches that show, hands up? And someone's wife watches it. Yeah. Who agrees she's an ethical lawyer? Hands up. Who agrees she's ethical? Those that watch it or those that don't? You agree? Okay. On the basis of? Vanessa, on the basis of? I mean, like, why do you hold that, like, why do you hold that point of view?
So she always she's very empathetic to
Okay. Who disagrees that she's an ethical lawyer in that fictional context? Who disagrees? You all think she's an ethical lawyer. What do you think about the client who is the drug dealer? Right? So one of her clients is a drug dealer, right? Right. And what else does he do? It's like a dry cleaning business.
He has to
Petra?
have the drug dealer business, and then what she represents is the legal side of his business.
So, is it ethical? Okay. So that's this character's ethical, context, right? Is she's got the drug dealer client, but every time she goes to court, she says, "I'm only here representing Mr. So-and-so for his legitimate businesses." So, right? Well, then that's okay, is it? Or is she building a wall to say, "Well, I know he's dealing drugs, but I'm only dealing with this." So the reason, good morning. Yes, in the floor eventually, right? Okay, I'm going to complain about this room. Okay, so the point. Okay, so this lawyer, I suggest to you, has a little bit of a gray area, right, in terms of her ethic. I agree in some cases. The presentation is very ethical and compassionate for her clients. On the other hand, there's this sort of mental distinction or wall that she, in the case of the one client,
I think that's the beauty about being a lawyer. You have to distinguishes a really good lawyer. Like, you can't in my opinion, you can't practice law like it's not black or white, So like you need to always find a way to ethically represent your clients by looking for these gray areas that you won't get into trouble.
yeah. I mean, I think that's a very accurate kind of portrayal of our profession, right? It's not black and white. There's no right answer. It's not mathematical. It's an art, not a science. And you have to struggle with these ethical dilemmas and land somewhere and make a decision and go with it. Okay, that's our lawyer for today. And today I think we're talking about clients. Ooh, clients. Okay, so here we go. My usual disclaimer. Hang on. Where's my disclaimer? My disclaimer. And we're talking about the lawyer-client relationship. It's that holy grail. It's that ultimate relationship you have with your client. It is, you can't even talk to your husband or wife or your partner about these clients, right? Because your obligation to them runs so deep. Okay. And so when we talk about the lawyer-client relationship, that harkens me back to something we talked about the first day. About
Zealous advocacy.
So let's do a little tiny one-act play. I need 3 volunteers. 3 volunteers. 1, 2, 3. 1, 2, 3. Come up here. 1, 2, 3. 1, 2, 3. 3 volunteers. 1.
Okay.
1, 2, 2. You better come here because these people you can't see. And 3. 3. I used it for a different class, so just ignore the blackout.
Okay.
Just ignore that. Okay, so we're going to go back and we're going to have a presentation, mini presentation. And you're going to read aloud, nice and loud, project. And we're just going to harken back momentarily to the first day. Okay, the first one, the whole thing nice and loud.
Hi, my name is Lord Chancellor Henry Brom, and I was a lawyer who lived in the 1860s, so I am long dead and basically speaking to you from the grave. I have some traditional views, and in particular, I say ice cream is the best. And I say that when it comes to dessert, I know but one dessert in all the world, and that dessert is ice cream. My first and only duty is to defend ice cream. It is creamy, it is cold, and it is delicious. I said something similar once on a topic of clients, and it can be found on page 28 of your textbook. I heard it was available at the campus bookstore.
Thank you. So that's Lord Brown, and you are next. You're last.
Hi, my name is Trevor Farrell, and I am a well-known and well-respected professor and author of many articles on legal ethics. I am alive and well, and because I am so well-known, if I died, you would have heard by now. I challenge Lord Chancellor Brougham on traditional view. I have a more modern view. I believe that there is a wide spectrum of desserts, and that we should consider different viewpoints about desserts. Frozen yogurt is an excellent dessert, so is gelato, and fruit-flavored ices are also delicious. They are lower fat than ice cream and come in way more varieties and flavors. I wrote something similar on the topic of legal ethics in an article I called Sustainable Professionalism, and it is excerpted in part of your textbook, which I heard is available at
The campus. Thank you. And last but not least, you're done. Thank you.
Okay, hi, my name is Timothy Dare. I am a professor of philosophy and law in New Zealand. I heard about Trevor Farrell and about Chancellor Bowman's viewpoints, and I wanted to add a bit of nuance to the discussion. I believe there are some very valid points of Bowman's point of view. Ice cream is a good source of calcium, for example. But while I defend ice cream as a good dessert with zeal, I am talking about a small portion size and ice cream with real vanilla bean, which is delicious. But a good thing can be taken too far, and let's not defend ice cream with hyper zeal, like adding peanut butter cups and Smarties and crushed Oreo cookies to ice cream. I wrote something similar on the topic, and you can read it at page 18 of the textbook. I don't know where the text is available because I live in New Zealand.
Thank you very much. Okay, let's hear it, please. Thank you very much. Okay, so that is like a little refresher on our notion of how we treat clients, right? So today, yeah, that's good. That's good, you guys. Today we're going to talk about the lawyer-client relationship, advertising, marketing, duties of profession, and then we have that basket of really good things, those really good things that are legal and ethical obligations to the client. Fiduciary, good thing. Loyalty, good thing. Candor, good thing. Competence, really good thing. Proaction and integrity, all good. Okay. First of all, you have to establish your client-lawyer relationship, right? The first thing you have to do is establish the relationship. And we know from our model code and into the provincial codes that a lawyer must make legal services available to the public efficiently and conveniently. And there's an ongoing debate about, are you required to take all potential clients? And we'll talk about it. And are you entitled to decline a client? We'll talk about that. And we have to avoid the accidental client. Okay, so I'm not going to take you there, but that's where the rule establishes the requirement for 4.1-1. Who is the client? When you belong to a big fat giant law firm, guess what? Any client of this partner, or this junior, or this associate, or this senior partner, or this retired partner, not retired, this working partner, is your client. And you may be in a big fat giant law firm where your office is in Vancouver, and your partner's office is in Halifax, and you never met the guy. He has a client, if you have a conflict, guess what? It's your client as well because it's the firm's client. No formality is required to establish the lawyer-client relationship. And so what do big fat giant law firms do to vet clients for that problem? What do they do? Does anybody know? Yeah, it's usually electronic. It's usually a database thing where we have a new client and it's sent out on the internal to say, here's any conflict, so the person in Halifax can read the list and say, oh, I once defended that guy, so we can't sue him. Okay, no formality is required in avoiding the accidental client. What does that mean? I need someone to go to 1.1, the definition section, please. Definition section of our rule. So one hands up, I need one voluntary reader. Nicholas, 1.1-1, so it's the definition section, this little,
Just the client part.
nice and loud.
Client means a person who consults a lawyer and on whose behalf the lawyer renders or agrees to render legal services, or, having consulted the lawyer, reasonably concludes that the lawyer has agreed to render legal services on his or her behalf.
Okay, let's break that down. Part A, what does Part A tell you? Nicholas, what does Part A convey to you? A client definition.
Someone who comes to a lawyer and seeks legal services.
And on whose behalf, so remember we have to look at the words, right? On whose behalf the lawyer renders or agrees to render legal services. We have a nice meeting, we agree, maybe I give you a retainer, and a retainer is two things. What two things is a retainer? It's money, retainer, money. Did I tell you about when I was a junior lawyer? Okay. There we go. I'm a junior lawyer. I'm like 1 year in. I don't know what I'm doing. And a client comes in, and I'm a lawyer of the day. When a new client comes in, I get him. I take him to my office, I sit down, I say, how can I help you? He says, hi, I'd like to sue the city. I'm taking notes. Okay, let's sue the city. What reason? He said, well, I want to sue the city because I am the king of the world, and I don't want them using King Street and Queen Street. And I say, would you excuse me, please, for one moment? And I leave him, go down the hall to my senior lawyer, like to my partner, like in the law firm, and I say, oh man, I've got this guy, he thinks he's king of the world, he wants, like mental health. And my senior partner says, okay, did you get a retainer? He says, did you get a retainer? He says, did you get some money from the guy? I thought it was funny. Because his thought isn't, the guy needs mental health. That was a joke. I mean, it really happened to me, but that was a joke. And then my senior partner helped him out and put him in the hands of someone that could help him. Okay, a retainer is money. Back on track. If you've got a better story, let me know. Because I want to hear your stories. I like that. But what's Part B? Okay, who can focus on Part B for me? Part B. Part B. Hands up. This is good stuff. Cassie.
Having consulted the lawyer, reasonably concludes that the lawyer has agreed to render legal services on his or her behalf, and it includes a client of the law firm of which the lawyer is a partner or associate, whether or not the lawyer handles the client's work.
Right, so client of the firm is your client, too bad for you. But look at the words. So a client means a person who, B, having consulted the lawyer, reasonably concludes that the lawyer has agreed to render advice. Whose perspective?
Client.
Not yours. Not yours, the client's. Now, how reasonable is that conclusion? Well, that all depends. What evidence can they marshal and so on. But this is what we call the accidental client, or as I like to call it, the cocktail party client. You go to a cocktail party, and you're minding your own business, drinking your martini or whatever you drink, and someone comes up to you and they say, oh, I heard you're a lawyer. Who's had that happen to them? What do you do, Petra, when they say that? I hear you're a lawyer. I was in a car accident. Let me ask you something. What do you do?
Well, it's more like a joke. Like,
You get a retainer.
There you go. That's
wait, but if I don't get a retainer, does that mean they're still my client? Because
Well-
isn't that like a contract? Like,
that is a
consideration?
contract. But let's see, what would the Law Society say? This is the same wording as Law Society. They would say, a person who consults a lawyer on whose behalf the lawyer agrees, that could be a retainer, right? Or, having consulted the person, the client reasonably concludes.
It doesn't have to be money.
Correct. So this is your black hole, right? Is you talk to someone and they reasonably conclude that you're acting for them, and then you get a letter saying, hey, dear lawyer, remember when I talked to you at that cocktail party? I talked to you about my motor vehicle accident. I just found out 2 years has gone by and my limitation period is gone. I've lost all my rights. And you go, what are you talking about? What cocktail party? So you have to be alert at all times to the accidental client, cocktail party client, because they conclude, too bad for you. What do you do to protect yourself against that? Louder, Vanessa.
Send them a non-retainer letter.
Which says?
So tell them that, so I have not been retained, and then also advise them that you have 2-year limitation period to avoid town bar.
I agree with that. So one option is, if you didn't hear it, is write the person a non-retainer letter which says, and this might be someone that comes to see you and then doesn't, as opposed to a cocktail party, although really, when you think about it, if you know their email address, and you say, you have not retained me. I will take no steps on your behalf. Like, be as clear and plain language and straightforward as possible to say, I'm doing nothing. You haven't retained me. I'm not acting for you. By the way, as a courtesy, there is a 2-year limitation period. But I am not your lawyer. I'm not acting for you. And you just use the language that is appropriate to that particular individual. So that's one option you can do. But I mean, if you never, like, if you don't have their email or mailing address, and you've just been to this cocktail party, you come home, and you're, getting ready for bed, and you think, oh, crap, did that person reasonably conclude that I would act for them? I don't even know who they were. It was a giant cocktail party. I met a lot of people. What else can you do to have a contemporaneous snapshot of what happened to protect yourself? What else can you do?
You could send a note to some kind of file or something for your...
Sure. Send it to yourself. Yeah, commemorate it in time to say, this date, this o'clock, met a person, talked about MVA, I will not act for him, I told him verbally, I don't know how to, whatever. Just capture what happened so that when you forget about it and 2 years later you get this letter, you say, hang on, I wrote a note about that. Yeah, makes sense? Okay. All right. So clients. So now we know that a client can happen accidentally, and we know that it doesn't matter what you think, it matters what the client thinks in terms of reasonable conclusions, right? So, are you under an obligation to take unpopular cases? Whether you have to represent an individual that comes to consult, right? And there's a debate. Yes, you should always take on clients, access to justice issues. No, you can choose a competency aside, right? Let's say it is your area. You can choose not to take a client. It's a business we're running here. So that's a debate that is ongoing and you can have with your friends at lunch. One argument is lawyers are not ethically compromised by the moral worthiness or unworthiness of their clients, like Alicia.
Oh, yeah.
Yeah, the good one, right? And contrast that with you might do more harm than good if you win. I'm going to ask you what that means. Jude.
No, I just wanted to say that I thought that the Norton Code said that basically you have to take on all clients subject to conflicts and competence.
I think it's more nuanced than that. Yes, competence. Yes, conflicts, for sure. But beyond that, I think the debate is, are you obligated to take every client? And some of the pros and cons are here, right? Yes, in the sense of access to justice, and you aren't reflected by the client, you are the lawyer. Others say that you can choose who you want to represent. It's, free country, but you can't discriminate. Joe?
Is a workload also a good reason to decline?
You can decline, you don't, other than discrimination, You can decline a client because you're too busy, because you're traveling, because in 2 years when the limitation period expires, you're going to be retired. Like, there's no like set limits as to, you can decline, you just do whatever, that's fine. Except you can't discriminate. I'm going to decline you because I don't like people with green eyes, like that kind of thing. You can't do that. Okay. What does, you might do more harm than good if you win, mean? Hang on. What does that mean? June.
So if there's a case on maybe a topic that you don't necessarily agree with, or if you think that winning this case may potentially change the law in a way that you think is negative, then you may not want to take that on because you don't believe it's right.
Okay, right? Just because your client wants you to go in and fight a cause and that you morally aren't supportive of. Exactly. What if you win? What if you win? And you've done more harm. Yeah.
Well, you don't want to be the lawyer that's known as the guy who got that murderer off or got that hateful speech protected because of, like,
Funny you should mention that.
Wolcott? Yeah.
Funny you should mention that because we're going to talk about that kind of issue exactly, right? Your decision to represent an individual has a number of components to it. So in Canada, there's no particular requirement, like there's no mandatory requirement to take on a particular client. Okay, you're not obligated. You know, usually, you want business. I mean, in the normal situation, you're out trying to canvass business. You're out trying to, collect clients. There's a rule against discrimination, which I've just mentioned, so that can't be your basis, 6.3-5. And some arguments in favor are, you're not the judge, you're an advocate. The judge will decide guilt or innocence or liability, what have you. The lawyer is a neutral agent, and moral non-accountability is a social good, promotes fair administration of justice. All good reasons why you should consider taking on a client. Monetary issues aside, competence aside, discrimination aside. The arguments that say you don't have to, law is an instrument of power, lawyers must make responsible choices. It's a debate. There's no right answer. It's gray, it's not black or white, it's not math, it's an art, not a science. And the code gives us some guidance. And in terms of guidance, we have, you must encourage public respect for administration of justice. Pro bono is always encouraged as a positive contribution to the community. But you can decline a client. And some of the examples that are given, and again, we have the do not discriminate. That's not your ground for declining. Because you're so morally offended in criminal law that you can't represent the person. You're just, it's an unpopular case. But you have to help the lawyer find another client. What is the notion of last lawyer in town? What is that concept? Last lawyer in town. What does it sound like?
Well, if everybody else has declined to take on the case for Mr. X, whatever.
Right? So Mr. X comes to you and says, I've seen everybody in this podunk little town. That's a regional issue too, in terms of availability or access to justice, right? In terms of a small community versus a large community. You may only have 2 or 3 lawyers in town, kind of thing. So the question is there responsibility when you're the last lawyer in town? Notionally, they tried everybody else. They're conflicted. They're morally offended. So what obligation lies to you? Doesn't. The debate. You have to think about it, right? Unpopular cases. Is there a duty to take on unpopular cases? Is it profession responsible to refuse some cases? Like someone said, you're fearful of being identified with the client, as in criminal law, such as Ken Murray, right? Remember good old Ken Murray? The debate is that you have to think about a client comes to you, and you have to think about whether you should or should not take them on, balancing those issues. Is it unethical to represent a client if you really think they should lose, right? What if you create law that you can't sleep at night? And should you put forth a technical defense to avoid justified liability? Is it appropriate? The person has missed a limitation period. You have an ability to waive it. Do you waive it, or do you hold steady for your client and say that's my defense? It's a good defense, and liability falls. And is that the right thing to do? So defending those we detest. So this is one of those, not in your textbook things, but an example of the kind of clients that sometimes it is difficult to decide whether or not to take on as a client. And this is an article actually from 2017 Lawyers Magazine, where in 1977 in the U.S., white supremacists are marching. They're marching, and the city shuts them down, says, nope, you can't march. We don't want that kind of nonsense in our town. And the ACLU, what's ACLU? Civil Liberties Union in the States, says, no, we think freedom of speech is more important. And the lawyer defending the white supremacist march and the young Jewish woman. Because he did the mental gymnastics, and he feels it's more important to support freedom of speech. That's a higher cause than this particular client. So that's an example. So that's 1977, before you were born. Some of you.
Yeah.
Some of them.
Thank you for that.
40 years later, it's August 2017, another anti-Semitic group, following the U.S. Events, and the ACLU again says we have a long-standing history of defending the rights of groups we detest because of the higher good. Because the higher good. So maybe this is a case where you do have to make law that you can feel good about it, notwithstanding the underlying client, right? And so in Canada, the CCLA, Canadian Civil Liberties Association, also defended Holocaust deniers. Same kind of concept, right? Defending those we detest. So you take on a client, you may not agree with them, but there's a higher issue. And this is another one of those FYI. So when it's FYI, you can skip it, don't take notes, read it later, or just leave it. It's just another example of a criticism of a judge appointed to the bench, and the critics say, but he was a criminal lawyer and he defended all kinds of criminals. Imagine that. And the argument is, well, he was providing a service and it shouldn't be related to his appointment as judge. And then we have another example of the Hatter case, right, Guantanamo Bay, and the advocates that acted for him, again, in some circles, not a very popular client, so the association with defending that individual was an issue there. Another example, right, also not in your textbook. So generally speaking, refusal of a client, you can debate all of those aspects, but you can refuse a client. For sure, if there's a conflict of interest. In fact, you can attack even if you want to. Competency, we know that. If you're not competent, no way you can't do it. Continue retaining with a previous lawyer, so you can't, it's sort of just a professional courtesy thing. You can't pinch clients. And if there's a legal purpose and so on. Okay, so we'll talk about marketing. Marketing. 20 years ago, you could not market, you could not advertise. Pardon me. If you were in a car accident, you couldn't give someone your card because that might be marketing. But that was the day. Now, lots of marketing, right? Television, buses, online. And our model code speaks to marketing. Our model code says that a lawyer you don't have to, you may make professional services available, provided that. Now here's some really key elements. Your marketing has to be demonstrably true, not just true, demonstrably true, accurate and verifiable. It can be not misleading or confusing or deceptive, and it has to be in the best interests of the public. So, what do you think about this? A junior lawyer and a senior lawyer form a firm. The senior lawyer has been out 20 years. The junior's been out 5 years. Can they market their firm as 25 years of experience in the area of family law? What does anybody think about that?
Combined years, so you might be okay.
Okay, anybody else? Anybody else? What do you think about that?
Because as you stated, it's misleading.
Right, so you have to run it through this filter, right? Is it demonstrably true? Is it accurate? Well, is it verifiable? Yes, you can check that. Is it misleading? Possibly, right? Yes? Okay, any other comments with that notion? And, yeah,
Yeah, I think this is misleading or confusion because you advertise as a firm, it's not an individual lawyer. So you say, you give the misleading statement that the firm has been in the business for 25 years instead of the more senior
Right.
20 years.
so you have to sort of be clear about it, right? Okay, so that's 4.2-1. Oh, and this is just some examples of advertising and marketing. Whoever has the old textbook, they have, well, in our new textbook, they have some examples, right, of some images and some marketing examples. Yeah, they're good. Diamond and Diamond we talked about last day. Diamond and Diamond has been the guest of the Law Society at more than once. And this is just another example where he's never tried a case himself. He's US trained and he's attracting clients, and some argue the problem is lack of consumer knowledge. And then there's some advertising fees and so forth. It's just another real world example of marketing and how the Law Society views it. And these are the limits on marketing fees in terms of percentages for fees if you do a contingency fee basis for your charges. And now we have Mr. Merchant. Tony Merchant is a lawyer in Saskatchewan. And Tony Merchant is exclusively class action lawyer. So that's his area of expertise. He does a lot of class actions. He's about this tall and I don't know, weighs like 120 pounds. So he's like a real lean, mean worker, and he is notorious for being extremely hardworking and prolific in his work. And what he does back in 2000 is he sends a bunch of letters to residential school survivors because he's collecting a class action group. And if you are not familiar with the Canadian history and residential schools, Google it. It's disgusting. I'm telling you right now. So it's a horrible historical event. And so what Tony Merchant is doing is he's trying to collect a class, right? So he sends letters to individuals. And what he says is, MLG, which is his law firm, he says, we've acted for First Nations before. Your compensation from this class action can be significant. He says, you have nothing to lose. And he says, you know, in the past, we, his firm, have gotten $50,000 and so forth for clients. He sends these letters. So it's marketing, right? He's trying to collect a class. And what happens is the Law Society says, so two recipients complain, the recipients of the letter. Law Society says, well, one individual, we're not sure that person was misled. But on the other, they found the letters, the Law Society, to be reasonably capable of being misleading to the intended recipient. They were concerned by the Law Society of Saskatchewan about the lack of detail, inconsistency of the no cost notion. Because what he does is he sends the letter, and we do have a page reference for this. This is good stuff. He sends the letter and he sends an attachment for a retainer. Please sign my retainer to be part of the class. Yeah, let's go to page 156. Yeah, let's go to page, sorry, let's try 160. 160. Yeah, okay, 160 reader, yeah, volunteer reader. Okay. Volunteer reader, so it's just this page 160, this little section here further.
Further, the reader is told that he or she has nothing to lose and will pay nothing if the firm does not recover on her behalf. This representation is not only capable of misleading the reader, no matter who he or she is, but is indeed misleading when compared with the agreement attached to same. The letter itself is in larger type and for the most part employs common parlance. The agreement attached to the letter, however, is in smaller type, follows the form of a contract, and employs what laypersons often refer to as legalese. It would not be unexpected that a reader would rely on the representations made in the letter rather than reading the agreement.
Thank you. So the Law Society says of Saskatchewan says, well, hang on. I know your marketing and I know your expertise is in class action, so you're all good there, right? But you got this letter and it's 12 font, right? Then you have this little retainer agreement in the back. It's like 8 font, right? And who reads the little tiny print term? Like even we don't, right? Some of us don't even read that when you take on your cell phone agreement or whatever. And so the notion is that, is it reasonably misleading to say you have nothing to lose, only if you win? A contingency fee program, no problem. I only get paid if we go and I win or we settle or whatever, no problem. But if you read the retainer agreement, the little 8 font stuff with your reading glasses on, it says, but if you stop being our client, you're responsible for costs and disbursements, courier, photocopying, filing fees, like you're responsible if you leave the group. So that's where the law study said, that's a little misleading, so we don't like that. Mr. Merchant, you're liable. Okay, so that's an example of getting in trouble with the marketing issue. The law study finds that marketing activities issues with lack of dignity. They found Merchant's conduct lacks dignity, it was in bad taste, inimical to the best interests of the public, and he was penalized because of the misleading letter. And 2015, so that was 2000, right? 15 years later, Tony Merchant, frequent guest of the Law Society of Saskatchewan, is then found in 2 motions. Now this is a news article, but it's references 2 class action applications, 2 motions, and his law firm takes a bruising from the Ontario bench because of poor choice in poor wording in the firm's tactics for marketing, and the justice says we smell ambulance chasing. So not very complimentary on the conduct of Mr. Merchant. And the reasons behind the 2015 are illegal fee sharing arrangements. The letter sent was found to be offensive. This is an FYI decision of what year? Oh, this lawyer has a marketing campaign where he links to a U.S. counsel, and the link is, it's one I mean, Ask Gary. Ask Gary. So it's the referral service. Cross-border, the law side did not like it. You can read that on your own. So in terms of your obligations, remember, you have to be courteous, civil, act in good faith, and be careful when dealing with the media. This harkens back to that notion of the public image, right? Maintain respect for the profession. Stewart Broadcasting. So Eddie Greenspan, who passed away, I don't know, 4 or 5 years ago. So Eddie Greenspan had a case. He's a criminal defense guy, and he has a case with a fellow charged, Stewart, his client, charged with vehicular manslaughter or something. He has a case, and a few years later, he does a television program. I've looked on YouTube, I can't find it. If you can find it, somebody tell me. It's called Scales of Justice, and he does a series of episodes talking about his cases, right? And he does a Scales of Justice episode on the Stewart case, and Stewart complains, the former client, right? He complains and he says, I don't want you talking about my case. Like, what are you dredging all that up for? And the Law Society says there's a breach of the rules. Excuse me. Because the Law Society says what you're doing is self-promotion. And Greenspan says, no, it's education. I'm talking about my case and how it, unfolded and my defense. And the Law Society says, no, that's self-promotion of how great of a lawyer you are. It's a version of marketing. You're such a good, efficient lawyer. Look what happened in this case. I'm so good. That's what the Law Society. And ordered him, Greenspan, to pay damages to Stewart, the client, the former client, I guess. And I'll give you a page reference, page 164. You can read about that. Okay, give me 2 more minutes, and I'll get you out of here. Okay. Your obligations to the Law Society include all that good stuff: competence, marketing. You also have to report the misconduct and dishonesty of other lawyers. And I think we touched on this before. Your duty triggers to report when there's a breach of the rules. And remember, we said think long and hard, be sure, be certain, be confident before you do that. June.
How often does that happen? Reporting on other lawyers?
Yeah.
I haven't heard of that too much.
It's not very common. It's not very common for the reasons you can imagine. We have to be careful, but for the grace of God, we report all our friends and our colleagues and so forth. Plus, you have to be like 100% certain that the clients are not being served. So if the guy's like passed out drunk every night, that's one thing. Or if he's taken off with trust funds, that's another thing. But generally, it's pretty
He's walking around nude all the time.
Yeah, well,
That one.
you might want to think about that one. Right? Public nudity. Okay, what did I say? Pardon me. Okay, so your duty is to ensure the administration of justice is conducted in an open, fair, impartial manner. That includes all those good things. And you have obligations as officers of the court, so that when you are in a litigation scenario, you have to treat the court, the witnesses with candor and fairness, avoid sharp practice. And again, it's this notion of upholding the profession and the administration of justice. And if you give, what's ILA, independent legal advice? What's that? What's that? What's ILA? Anybody ever given ILA? Okay. Yeah, they want an independent perspective. They have a lawyer, but you say, go get ILA because I'm telling you something and I want you to have another screening for it. And if you give ILA, you have to be competent in the area. Same rules apply. And you have to ensure your legal advice is adequate. Unrepresented litigants, this is your nightmare scenario. Okay, I'm going to let you go. We'll pick up here and 10 minutes. What's your favorite thing, for sure? When you have an unrepresented litigant, we know that the rules say a person can represent themselves, right? Because obviously lawyers are expensive, that's what I heard. When a lawyer deals on a client's behalf with an unrepresented, so you've got a client, you know, representing that person for whatever reason, but the other side, no lawyer, just that person, the other side, just themselves. You, as the lawyer for your client, must first be self-rep, unrepresented, same difference. The self-rep to take independent legal advice. Representation, you say, you know, I encourage you, if you can find someone that will help you. You have to ensure that the self-rep is not proceeding under the impression that his or her interests would be protected by you. You would be surprised, especially if you're a nice person, which we all are, how often a person will think, oh, well, you work it out as between the two of us, you represent both of us, even if they don't use that language. They have to take care to make sure that's clear, and that you are acting exclusively in the interest of your client and not the other person. If for some reason the circumstances allow and you can do both people at once, it's a joint retainer, and there are rules about joint retainers, and if that's the situation, then you better check your rules on joint retainers. Okay. And the model code, read 7.2-9, that's what the model code said, we just did. And good, okay, good. So that's just the commentary, right? Okay. So when you're acting against a self-rep, you cannot take advantage of their lack of knowledge of the rules of procedure, limitation periods, and so forth. So you can't say, oh, this guy doesn't even know that he has to make a filing within a certain deadline, failing which I can bring summary judgments on. You can't take advantage of that. Now you got to balance it, right? You can't call up and say, oh, by the way, I should tell you that you have a limit, you've got a deadline coming up, and because that person might assume, oh, you're protecting my interests as well as the other side, you want a fair outcome, so you're helping us both. No. Dodgy ground, be careful, okay? So in this case, summary judgment in favor of the defendant dentist. Dentists, they're the worst. They're smart, they have they have medical jargon, they make a lot of money. So in favor of the defendant dentist was overturned because the self-rep plaintiffs failing to provide an expert report on injuries was problematic. The defendant did not in turn put their best evidentiary foot forward. So the moral of this case, of this story, and do we have a page, is this in the book or is it not? I think it is. No, maybe not. Do I have a page reference for you? I do not. So, you'll have your index. You can see in your index if it's a case of law. The moral of the story is, when you have a self-rep, you cannot take advantage of their lack of knowledge in the area or the field, because you, it's not ethically acceptable according to our rules. There's an unspoken concern that lawyers with more knowledge and expertise than non-lawyers will use that knowledge unfairly. The consequence is that legitimate cannot be heard on the basis of inexperience, inexpertise, lack of expertise of a self-rep. We guard against that. In that case, the court acknowledged that the self-reps are entitled to expect the same rules and practices. They still apply. They still apply, and they have to follow the rules, but it's not fair for you to take advantage of those rules because of that person's lack of knowledge. And by the way, another reason why it's a screeching nightmare is when you get to a hearing and the self-rep stands up and says something, you say, I object, not relevant. The judge says, I'll still hear it, right? Because they're being a little bit more accommodating to the self-rep. In terms of perception, the person doesn't want to be shut down. So that's, it's not good. It's not fun. A further problem is the creation of a hierarchy of case law and precedent. If you're taking advantage of someone's lack of knowledge and you come to a result and it sets up a chain reaction. Cases involving self-reps, there are lower standards of evidence. That's another concern. So it's just a problem. It's a big problem in business. Remember, we're a self-governing profession, and we need some rules respecting how we behave with others that are not in the same profession as we are, and we cannot take advantage of our self-rep cases. Okay, so then the next section, before I leave this last section, I will I'll give you a page reference to page 416. 416, top of the page, for a case called Rondell and Worsley. And that references the officer of the court notion, and that section, just to save time, 416 in part, the reasoning reads, counsel must not mislead the court, must lend himself or herself to casting aspersions on either party or witnesses for which there is no sufficient basis on the information in his or her possession. That speaks to that notion of civility. This is in a litigation setting, right? Because you won't all be litigators, but when you are, you're an officer of the court, so you represent the whole administration of justice. Rondell and Worsley case, that's your page reference. Okay. All right, now we're going to talk about legal and ethical obligations to the client. And you have a whole whack of them. And those are all those good things at the top of the class we itemized. All those good things. Fiduciary loyalty, candor, competence, integrity, all those good things. Those good things that we wear as our cloak of respectability, right? So fiduciary. What is the essence of a fiduciary relationship, which is your client-lawyer relationship? Like, what's the hallmark? Anybody? What's the Julia?
Is it a relationship that involves like a trust or a trust between like loyalty and trust?
Okay, and how does that trust flow between the two parties?
There's I think an agent and a principal. So someone who's like, I think the lawyer would be the principal and the kind of the agent or the
Trustee.
Yeah.
The lawyer would be the trustee.
Kasim?
Yeah, the lawyer would be the trustee and the client would be the beneficiary.
Right, I think it's trustee and beneficiary is
sorry.
kind of more how it's, couched, Jeremy.
Yeah, so the trustee has to also act in the best interest of the beneficiary, so using money they give you to make sure that, I guess, you're fighting the case to the best of your ability.
Yeah, and also don't pinch the money, right? There's an asymmetry of power, right? The trustee is reposed with trust. So you know how legal words have meanings, like trust means something, and then just plain good old English language, it means something. But it means something more, right? In our context. There's an asymmetry of power. The lawyer must exercise skill, expertise, only for the client's benefit. And note that the lawyer has special obligations to the client, not fully able to make decisions for themselves due to age, information, capacity, or other reasons, but it also includes expertise, right? Because they don't know the law. So the beneficiary is reliant on the lawyer that has this knowledge and skill and so forth, and that's your imbalance of power. So you have fiduciary duties. It's the highest duty at common law, the highest duty. We have a very high obligation. So some of the rules that flow from that are 3.6-7. You can't share fees with non-lawyers. You have to, keep it in the profession. 3.6-1. So the fiduciary duties are throughout the model code. But these are a couple of examples. Yes, Petra.
Yeah, I wanted to ask, what if, so in terms of sharing fees with a non-lawyer, how about a private investigator?
Well, it depends, right? Are they an employee of your firm? Do you use them on a regular basis? Are they salaried? That's not really fee sharing. Remember the case of 1-800-CALL-GARY? That was where there was a cross-border relationship. So it's contextual. It depends on all of the facts. So, but you can't share your fees with a non-lawyer. Subject to, is it an employment arrangement? Are they part of your firm? Is it a clerk that works in your office? Is it someone you retain on? There's never a straight answer, right? I know. Strother. So Strother is a case of the Supreme Court of Canada. And you know how the Supreme Court of Canada is? They can't write a 10-page decision. No. 150 pages minimum. So Strother in 2007, so Mr. Strother is a lawyer, and he is, I want to say BC. He's at Davies LLP, and he gives tax advice. He's a tax lawyer. That's his area of expertise. That's where he's competent. Off you go. Tax lawyer. And he has this client called Monarch, which is a corporate client, and he gives tax advice for tax shelter investments for film production. That's what Monarch is. And he all these tax incentives and so forth. So what happens is, in '96, the legislation that forms the basis for the exemptions is ended. New tax rules a year later. He doesn't tell his client. That's a good question. He doesn't tell his client. In 1998, he takes on a new business because now the tax rules have changed again. Only this time, he's involved in the business. He takes advantage of revised tax rules with a financial benefit to him. And we'll talk about Strother in the context of conflicts in a lot more depth because Supreme Court of Canada, we have to follow their jurisprudence. But this little kind of just a taster of this is Monarch sues Strother. This is Monarch's member company. And the Supreme Court of Canada finds he breached his fiduciary duty, right? That fiduciary duty, that trustee, beneficiary, imbalance of power duty breached. Supreme Court of Canada, and we'll talk more about it in the conflict section, but this is where it comes up here for this. What the Supreme Court says, the majority says, his duty of loyalty is violated and breach of fiduciary is established when he acts in the interest of someone other than his beneficiary, trustee beneficiary client relationship, which is the first company, right? Because tax rules change, he doesn't tell his client. Whatever he undertook to do, he was bound to do in accordance with his fiduciary obligations. So just in the fiduciary, pool right now. So, outside business interests, go ahead, coach your son's baseball team, raise money for cancer, speak at junior achievement. Go ahead, no problem. But if you engage in another profession, business, or occupation concurrently, if it's a paid occupation, you must not allow that outside interest to jeopardize your professional integrity, independence, or competence, whether you're paid. I mean, it's hard, to have two jobs, like you're busy enough, but you can't let those two cross over, paid or unpaid. So that's fiduciary, at a higher level. Loyalty, another one of those, like sometimes they're called the 6 golden sisters, right? Those 6 concepts that we have to always carry with us. Loyalty has 2 obligations, right? You have to place the interests of the client above those of others, beneficiary, yeah. And you have to place the interests of the client above yourself. Don't pinch the trust funds, for crying out loud. Write that down. Do not pinch trust funds. Back. And so don't forget, when we talk about loyalty, that kind of touches on Mr. Strother again, because after he dumps the first client, the second client he goes into business with, and guess what? He earns money. That's putting his interests, his personal. Justifications for loyalty, like we need a justification, right? A client, you have to give your client a loyal, giving a client a loyal advocate allows the legal system to function efficiently. Individuals have a right to have a lawyer, and there's an access to justice. I mean, access to justice really can underlie so many of these things in terms of how a person has and receives justice. Because the lawyer can do what the client can't do for themselves, beneficiary trustee. But there are some limits. So you're a lawyer. Your client asks you to do something and put you in breach of the model code or your provincial code, right? Well, you can't do that. Did we look at to and do of a client? Remember that? Whatever rule that is, it's in the commentary there, right? I mean, you can't act for your client when you're in breach of your own rules. And strategy overrides instructions. Why? So you have expertise, you have training, and you say to the client, the limitation period is going to expire, we have to file something. You're on solid ground, right? The client tells you, I want you to use this strategy, make sure you ask a lot of questions and cross-examination about blah. But you get to say yes or no. Why? In other words, you take instructions after giving advice, but on strategy, it's up to you. Why?
Because you are the professional.
Emmanuel, you're the professional. Erica?
Also because aren't you more competent than the person?
So because you're more confident and you're more aware of the legal scenario as compared to the client, so you're in a better position to advise them to do something and not do otherwise.
Okay, Jeremy?
At the end of the day, you have the duty to represent your client in the best way possible. So with your legal knowledge, they may not be thinking in a legal way. They may be thinking for something more personal when they ask you what to do. So you know technically what's best for them, not what they think is best for themselves.
Right, because they're personally invested, and you're supposed to be the advocate and the agent and the advisor. What?
Because he hired you. Because he looked for you. And that's, in my opinion, manifestation of the client willing you to help him in your professional way.
Including strategy.
Yes.
Jim?
Well, I think pretty much everybody said. That's what I just wanted to say, because we hired you for your expertise.
Yes.
And so strategy is a part of expertise.
It is a part of expertise. Yeah, exactly. So you bring all of that to the table, and you have a strategy that is based on your experience, your education, your area of practice is going to be more successful, so you're trying to do the best for your client. Jeff?
Leapfrogging it then, if you ignored the client's advice or instruction, took his instructions rather than strategy that you wanted to go ahead with, I mean, the long-term result of that could be that your client's fees go way, 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 way up, and that's not in the best interest.
And what do you do about that?
Well, if you know that this is going to have a negative impact, then it's like, dude, you're going to pay a lot more money because it's going to be appealed or, or whatever.
Yeah, exactly. So in terms of taking instructions on, not strategy, but taking instructions on how to take a step in the litigation, for example, and you know it's going to cause these problems, more fees, more time, more delay, costs, and so on, you have an obligation to tell your client before you take on those instructions. And they can say, no, I insist you do it, and then you put it in writing that you told them. Loyalty. What are the concerns about loyalty? Well, is there a moral imperative arising from the lawyer-client relationship? Its central feature of advocacy for clients' interests is the absence of a moral accountability for a client's aims. So your loyalty to the client, in some, like, you know, it's debatable, in some circles are, well, I'm loyal to my client. The issue, the moral issue is his, not mine. Back to Strother. The duty of loyalty is not a duty in the air. It's not intangible. It's not just something out there. It's real. It attaches to the obligations. And Mr. Strother went offside of that. This is the language the Supreme Court of Canada used in that case. Candor. Remember our 6 golden sisters? This is number 3. Candor. Our model code says when advising a client, a lawyer has to be honest, candid, inform the client of all information known that may affect the interests of the client, such as if we take this step, there's going to be an appeal, it'll cost you more money, it'll take more time, you're going to lose, you know, your edge. But you have to be honest and you have to exercise candor, and we'll see later down the road when your client wants you to do something, you have obligations to say, I could do it. It's not the best idea, and here's why. And you have to be honest and not just do what the client wants. In 3.2-2 in the commentary, you have to disclose to the client all the circumstances of any relations among the parties. You just disclose, so your client has full knowledge and they can choose to stay with you or continue with your retainer or not. But you have that obligations in the commentary. And you have to give the client a competent opinion based on sufficient knowledge of the facts. Remember good old confidentiality? How do you have all the facts? Because they know you will keep everything that they say to you in confidence. The advice must be open, undisguised, clearly disclose honestly, what they think about the merits and the results. And you may have to be firm with your client. You may have to. It's not pleasant, but you have an obligation to it. Firmness without rudeness is not a violation of the law. Competence. So we talked about competence. So competence is, unlike sort of loyalty and fiduciary, which are obligations that you have to sort of work through, competence is a little bit more straightforward. Like, are you competent? You must perform all legal services undertaken on a client's behalf to the standard of a competent lawyer. Standard of a competent lawyer. What's the standard? It's not perfection, right? It's a competent lawyer subject to your age, your experience, your background, your area of interest. Can you become competent? So the lawyer owes a duty to be competent to perform any legal services undertaken. And, you know, are you competent to undertake that duty? Have you taken on that duty for this particular client because you're the last lawyer in town? You got to balance all of those concepts. You should serve the client. Excuse me. In all these good ways, right? You must be conscientious, diligent, efficient, provide a quality of service at least equal to that which lawyers generally would expect of a competent lawyer in like situation, in similar situations, which is that notion of standard, right? The standard to which you are compared. Yes, Jim.
I saw in one of the readings a definition that includes integrity in competence. Yes?
Yeah, I mean,
that was a little bit unclear how.
Yeah, they kind of overlap, right? I mean, they're not like isolated concepts. They kind of overlap in the sense of how you behave, your moral, ethical lawyer. It's all kind of built into these different types of behavior. So I don't think they're watertight areas.
As part of competence.
Sure. I think, you know, integrity is like, I think we said that all of chapter 2 is about integrity, right? The whole chapter, there it is, the whole thing says, thou shalt act with integrity. Like, it's just fundamental. And there's some overlap, for sure. Competence, yeah. So you must maintain your skills. Failure to do so might mean professional misconduct under the rules, even if incompetence is not bad enough to qualify for civil liability. So we talked about your continuing professional development, CPD, obligations, right? And we talked about how many in a year in Ontario? 12, Ahmed, 12, of which, how many are ethical hours? 3 are ethical hours, this kind of stuff, and then we have the new EBI rate, which is end of 2020, so it's amazing. By the time you get out of here, in the bigger sense, those will be obligations. So you must maintain your skills. You have to take CPD, right? Mandatory. A lot of professions have that. Lawyers should only take on cases in areas in which they have sufficient knowledge or can quickly become competent. And what were the rules about becoming competent? What were the rules about becoming competent? You inform the client, correct. What else? Chendi, what else? Competence.
That you can do it as soon as quickly as possible.
Yes.
Speed.
Yes.
Knowledge of law.
I'm sorry?
Knowledge of law.
Yes.
Must be done at the expense of the client.
Yes. Who is that? Jean? Yes. It cannot be done. Someone help me. Where is the rule? It's in 3. Good old 3.
It's at 3.
No expense to the client.
3.1.
Huh?
3.1
3 point. I just can't hear you.
6.
3.1-6.
3.1-2.
Yeah. Okay, so you know what? Okay, I'm just trying to save time. It's in there. We can find it. Let me just get through the slides, then we can finally look at it more closely. But you're right. You have to become competent. You have to advise the client, right? So disclosure to the client. You have to become competent in a fast manner or a reasonably efficient manner, and it can be no extra cost to the client. You can't say, I'm going to take a course at Harvard, so I'll just bill you for the flight and the course and the Fairmount Hotel in Boston. Right? That's my clicker. Favorite thing, clicker. We'll find it. I'll find it. You'll find it. You find it. You're all smart. Huh? Is it? So it has those elements, right? Is it the commentary? Yes. Just read the rule number and the commentary.
3.1-1 should I read the whole thing?
No, just give us the citation.
The competency is 3.1 and section 3.1-1. Competency, lawyer means a lawyer who has applied the relevant knowledge, skills, and attributes in a manner appropriate to each matter undertaken on behalf of the client and the nature and terms of the lawyer engagement.
Yeah. And then, but then where's the section about timely and no cost to the client?
3.1-2-6 or 3.1.
There you go. 6 ABC. There you go. Right? It has all those elements. So it doesn't mean you can't ever branch out from intellectual property. You can go do something else, but you have to satisfy those rules. Okay. How are we doing? It's right there. It's like I was anticipating. Okay, so thank you for finding it. It's right there. You cannot do so. Okay, unless you can do it quickly. Recognize your lack of confidence. Get the consent. Collaborate. Well, yeah, another thing is collaborate with someone. And it has to be no cost to the client. You can collaborate, and I think, did we talk about this? Did I mention Martha Stewart? Remember Martha Stewart? Insider trading. She goes to court, and she has 2 lawyers. One lawyer is like the lawyer handling the case, but the second lawyer is her son-in-law. So there's that notion of he is like family, it's all about perception and the image and so on. She went to jail anyway. But that was a case where they brought someone else on. So you have the name recognition or whatever that you may want, and then you have the person that actually has so bringing in your second chair, or you become second chair, as the case may be. Okay. Okay, so examples of how to treat your client. Keep your client informed, answer requests for information. Your client, does anyone have practiced, who's practiced? And did you use text, like if your client texts you with a question, did you use that? Communication? And what was sort of the expectation about when you would respond?
Immediately.
Huh?
Immediately.
That's what they expect, right? Yeah, fair enough. So, I mean, set up your own rules and guidelines as to how you want to use that. But reasonable requests for calls, do what you promise. I mean, your mother taught you that, right? When you were 5. Do what you promise. Answer correspondence. And we've seen that some of the complaints of the Law Society, a lot of them are about communication between the client and the inform clients of settlement proposals. That's, do I have it next? No. Settlement proposals, obligations to, so okay. You could settle because you've got a settlement proposal on the table, or you go to 6 weeks of trial. What's going to earn you more money? Right? However, too bad for you, because you have an obligation to settlement. 3.2-4, you have to encourage compromise or settlement. Right there in the rule. Why is that a rule? June and then Jill and then Jenny.
Because it's expedient for the court and it keeps everything flowing. In addition, the client is not charged as much.
Yeah, exactly.
Building on that, if you're not encouraging settlement, it could look like you're acting in your own interest.
Because 6 weeks of trial.
Yeah.
Can't do it.
Same as us, and Portugal, the dispute resolution was 9 years or 50 times.
Yeah. And by the way, real world, right? North of 95% of things settle. Litigation's very expensive, it's time consuming, it's stressful, it's emotional, and all those kinds of things. And the best settlement is one where nobody's happy, right? Why do
I
you
just
say
wanted
that?
to say that it's going to be
Right.
presented a win-win approach to both parties.
Yeah. No one's totally happy because you've given up something, I've given up something. That's how we settle. We come to a middle ground, right? Okay, you have to be complete and accurate. You have to provide a prompt and complete report when you're done. That's your bill, right? With everything that you did, what you're charging. Avoid self-induced disabilities such as intoxicants. Write that down. Don't drink too much. Okay, we have a case. I probably know a page reference for it. Ritchie, the Ritchie case. Where's Ritchie? Ritchie, yeah. Ritchie is at page 176. And this is the case of a senior experienced member of the bar, allegations that he failed to communicate, didn't do filings on time, had inadequate file management. He's fined and reprimanded all those failures to serve the client properly. That's 2001. Going back to 1994, Law Society of Alberta and Mr. Syed, he failed to serve his client in a diligent, conscientious, efficient manner. Clients complain, Law Society calls you, your phone shows 416-947-3300. Drop your mouse. Take the call. We know why, right? It was a criminal matter. He spent insufficient time interviewing a client. He didn't know basics like his age, didn't know all the defenses, did not interview witness statements. Law Society can't call him. Frazier, 2011. A school teacher is accused of sexual impropriety. The issue was the conduct of counsel at trial and appeal. The court found, this is a criminal case, right? The counsel was incompetent, filed an affidavit when it was not necessary, didn't pursue evidence, didn't advise, didn't conduct adequate cross-examination. So your liability can be in contract or in tort. Right? Liability, negligence, okay. And your liability in tort can be mistaken advice, failure to give advice, error in litigation, carelessness. And we mentioned Rondell v. Worsley. I gave you the page reference if you still need to come and see me. It's a source of a lot of our fundamental notions of how a principled lawyer should act. Client cannot sue a lawyer for strategic decisions, right? We just talked about that in the conduct of the case. But if it raises the possibility the client sues for negligence, it would make it harder for the lawyer to follow the views of the court and the public interest. So negligence, you can be found liable for in tort, and then contract would be on your retainer, right? Failing to do whatever you set out in your retainer that your client pays you to do. Proactivity You should be active and vigorous, and so you can't take the money, get the retainer, put it in your bank account, and maybe look at it in a couple of years. You have to advance all arguments, seek all remedies, but you must not engage in frivolous or vexatious behavior. Now, good old integrity again. Good old chapter 2. One rule, integrity. 2.1, duty to carry out your practice. Discharge your responsibilities with integrity. And then we know when you have another profession, Rule 7 speaks to that. It's a fundamental quality of a person seeking to practice. Integrity, right? It's that large notion, and like these things flow one into the other. If personal integrity is lacking, the lawyer's usefulness to the client is zip, right? And the reputation within the profession will be destroyed. Even if you're competent, if you lack integrity, dishonorable or questionable conduct in private life or professional practice, conduct unbecoming, professional misconduct, reflects adversely upon the lawyer, and the profession, and the administration of justice. You're carrying all this stuff on your shoulders, okay, when you stand up in court, and your behavior reflects that. Told you I'd catch up today. Bye, Tracky. Okay, so I'm going to stay for a few minutes. I think we can. What time is it? Look, we ended early. I know. 2 minutes. I'll stay for a few minutes. Otherwise, for anyone that missed it, this morning's announcement, we didn't do a joke. We have time. Is that November 12th for your presentation of your assignment. We have way too many people to fit you into 2 hours. I have to figure it out with the office. We'll have to do something. I'll bring you up. I don't know, whatever. I'll let you know what goes on. I'll put on a little quick. The joke before you go. Joke. Lawyer gets into a car accident. Crashes his car. EMS show up. And say, sir, are you okay? Stay with me. And he says, what happened? Bad car accident, sir. Your car was destroyed. He says, oh, not my Porsche. EMS guy says, sir, really, calm down. It's just a car. You are lucky to be alive. You lost your left arm in that accident. And he says, oh no, my Rolex. Yeah.